Sorry, I didn't realize I was on mute. But good afternoon, everyone, or good morning, depending on where you are. I know we have people all across the world joining us today, and I can see people coming in. But I think we should give like 3 to 4 minutes more, just waiting for the rest to join us before we begin. Thank you so much for being here today.
Morning, everyone. Apologies, I'm late. Huh?
Hi, Yusuf. No worries at all.
Morning, Dr. Bronwyn.
All right. I think we should be good to start now. Just also conscious of the time that's passing by. Okay. All right. Hi again, everyone. I see some familiar names here, but for the others, I'm going to start with a quick introduction. My name is Nandini. I work as the South Asia Regional Litigator for the Global Strategic Litigation Council. I am based at the Migration and Asylum Project in New Delhi, India, where I also work as a refugee lawyer. I will be co-moderating this workshop with my colleague Maureen, who is GSLP's regional litigator for the East and the Horn of Africa. Before we begin, I would like to give you a quick rundown on GSLC and what we do as an organization. So we are essentially a coalition of regional networks in Americas, Africa, Europe, and Asia. We have over 550 members, which are essentially organizations, nonprofits, lawyers, researchers, experts who work on strategic litigation and legal advocacy for the protection of refugee and migrant rights. As an organization, we support our members in fighting back hostile policies that are being implemented all across the world. We help them set priorities for their work to protect these populations. We build community and share knowledge. And we also create and execute litigation and legal advocacy strategies while also providing technical support in facilitating these strategies. Um, if you would like to join the council, I will shortly be dropping a link to our registration form. Please do fill up the form and you will be contacted by my relevant colleagues further. So yeah, back to our event today. Thank you so much for taking out the time and joining our virtual global workshop on access to citizenship for refugee and migrant children, challenges and strategic responses in Africa and the Asia Pacific. I think this session really comes at a crucial time where there's countless refugee and migrant children around the world who remain at the risk of statelessness. They are often born into a legal invisibility, denied a nationality, and cut off from some fundamental human rights. And weak legal protections or gaps in nationality laws, restrictive and discriminatory practices have led to this unfortunate reality where many migrant and refugee children are forced to grow up without any legal identity. And the impact of this is quite profound and long lasting, preventing children from accessing the protections they need to live a dignified life with holistic development. And these barriers unfortunately persist despite having clear ties to a country, either through descent, through birth, or long term residence. But as we will hear today, there is also a space for action. This workshop, in fact, brings together experts, lawyers, advocates from across Kenya, Zambia, South Africa, South Korea, Pakistan, Bangladesh, and more. Individuals who have been directly engaged in legal action and reform to uphold children's rights to nationality and end statelessness. Their insights are not just theoretical, but grounded in practical effort and hard won lessons. Shortly, we'll have a quick round of introductions before beginning the workshop, but I quickly want to highlight before that we see this workshop as a platform for mutual learning and collaboration. And you will shortly hear from our panelists, but we hope for this to be more than just a one-way panel discussion. And we want it to be an interactive workshop. And I believe most of our participants today, our audience today, must have received my email. But as we want to create this collaborative space, you as the audience will also get the opportunity to speak and interact with the panelists and the other participants after the initial panel discussion. We want to learn from your experiences, from your jurisdictions across regions, and your advice as a practitioner and expert, and your practical suggestions will be incredibly valuable for this dialogue. So please do keep this in mind as we go through the discussion. If you wish to speak later, we will guide you accordingly at the time. Yeah, on that note, I think we can dive into a quick round of introductions. We're very fortunate to be joined by a remarkable group of advocates and experts who bring diverse experiences and insights from across the world. I kindly request each of the panelists to introduce themselves to help us get a better sense of the different contexts and perspectives that will be represented here today. I think we can start. Maureen, do you want to start? And then we can pass it over to the next colleague.
Yeah, my name is Maureen Okoth. Thank you, Nandini. My name is Maureen Okoth, and I'm the regional litigator at the Council for the African Region. Thank you, and I pass it over to Ibrahim.
Thank you, Maureen. Good afternoon, everyone. My name is Ibrahim. I'm based out of Bangladesh. I'm a researcher. I work at Bangladesh Legal Aid and Services Trust, and I oversee our refugee legal aid programs to the Rohingya refugees here. I'll pass over to Yusuf.
Thank you. My name is Yusuf Bashir. I am a Kenyan lawyer, and I work with Haki Sharia Initiative here in Kenya.
I think Umar's next on my screen.
And I pass it on to Omar.
Oh, I'm sorry, Umar, you're on mute.
Right. My name is Umar Gilani. Hello, everyone. And I am a lawyer based in Pakistan. I practice both in the lower courts and the Supreme Court of Pakistan. And I'm very happy to be a part of this initiative. I will speak more about my work and my thoughts on the subject later.
Good morning, everyone, and afternoon, the other places. My name is Isaac Mwanza. I am the Executive Director of the Zambian Civil Liberties Union, from Zambia. We are involved in litigation work on refugees, citizenship for refugees and their children. Thank you.
Hello, my name is Youngsil Kwan. I'm from South Korea. I'm an attorney at Dongchan Foundation, focusing primarily on migrants and refugee rights. Thank you. Should I pass to Tandake?
Thank you. Good morning, everyone. My name is Tandika Chalke, and I am the advocacy lead for the global movement against statelessness.
And I think I'm last. I'm Bronwyn Manby. I wear different hats, but I teach international human rights law at the School of Advanced Study, University of London, and I write on nationality and statelessness. And I think the reason I'm here is that last year was published a guide on litigating nationality, which was jointly published by UNHCR and the Open Society Justice Initiative. Thank you.
Thank you very much, everyone. I think we can head on to the panel discussion. Maureen, if you'd like to take over.
Thank you, Nandini. To start us off with the panel discussion, I'd like to invite Mohammed Ibrahim Ahmed to give us an overview of the Bangladesh context, challenges in addressing accessing citizenship by descent in Bangladesh. Thank you.
Thank you, Maureen. I'll just quickly share my screen. Hopefully everyone is able to see it. So before I start off on the topic of citizenship rights for children, I just want to give a very quick 2-minute rundown on the legal status of Rohingyas in Bangladesh. As we know, Rohingyas have been residing in Bangladesh for a long time. The first wave started in the 1970s and then 1990s, and then the latest one in the 2017. But at this time, there is still a lack of a clarified legal status, but they are what we can assume from precedents, court judgments, and Bangladesh's engagement with the International Court of Justice is that they are lawfully residing in Bangladesh under a prima facie determination of humanitarian need, although this has not been spelled out in writing. But they are, because of the fact that there is a lack of a well-defined legal status, they are subject to strict administrative restrictions and often branded as refugees, foreigners, outsiders, infiltrators, a number of different tags depending on the context and also depending on the discourse at that time. And also, it's important to note that they are both de facto and de jure stateless in the context of Myanmar and Myanmar citizenship laws currently, but they are categorized as Myanmar nationals by the Bangladeshi state, and it is an executive decision, particularly to bring them under the ambit of the Foreigners Act 1946. And this particular act is very draconian in nature. It grants the state wide-ranging powers to limit their mobility. It grants them power to restrict them to certain areas, and it also grants them power to prohibit their engagement with Bangladeshi citizens. And this is also, it's important to note, a very colonial legacy of the South Asian region. Most of the countries here still operate the Foreigners Act. And again, important to note here is that only the Rohingyas who are registered with the UNHCR in the camps and are resident in the camps are afforded what we can call this humanitarian leave to remain. All others who are found outside the camps for some reason or are not registered are charged and sentenced under the Foreigners Act and sent to prison. So this is sort of a very brief rundown of what the Rohingyas have in terms of a legal status in Bangladesh. And moving on to the issue of the personal status, which we will be discussing more in terms of the practice on the ground. Rohingya births and marriages are both regulated within the confines of the camps. So there are parallel processes that have been developed by the camp authorities to register both births and marriages. And what this means is that there are birth and marriage registration processes within the specific camps. And the camps in charge, the people who are authorized to sort of run the camps, the administrators, they're able to provide a birth confirmation notification. And it's important to note that this is not a certificate, because this is essentially a slip that they receive first by the hospital where the children are born, and then they're taken to the camp in charge office where they are presented another slip through which the refugee children are able to be added to the ration cards. And so this is not a certificate, even though the Bangladeshi state would like to claim that it is. Uh, because there is actually no specific use or recognition of the certificates of marriage and birth outside of the confines of the camps. And so any kind of personal disputes that arise from issues relating to marriage or issues relating to guardianship or maintenance of children, they're not able to be taken to court. And we have tried this several times through BLAST, and we have always been rejected on grounds of there is no locus standi, the law doesn't allow Rohingyas to come forward with their disputes. And so there is a sense of lawlessness there. And then there is a sense of sort of lack of enforcement in these issues. Although it's important to note that as part of its obligations under the Convention on the Rights of the Child, the Ministry of Law, Justice and Parliamentary Affairs in Bangladesh provided an administrative order in 2022, which said that birth certificates could be produced and procured by Rohingya children, provided that it is endorsed by a local court and by the camps in charge. Now, the problem with that is for
I think he may be having some connection issues. Perhaps we can wait for a minute, see if he is able to rejoin us. Hi, Ibrahim, can you hear us?
Yeah, hi, apologies. My power went out, so
No worries at all.
yeah, I'll just start off again if that's all right. Are you able to see the screen again?
Yes.
Okay. So yeah, I'll run through quickly now. So essentially, there is an administrative order in 2022 which said that birth certificates can be provided, but it needs an endorsement of a court and the camp in charge. However, because of the fact that Rohingyas are not able to leave the premises of the camps unless it's for presenting yourself in court for a hearing or to visit your family in prison, so they're not actually getting the exit passes to apply to courts for these birth certificates. So essentially, procedurally, it's really not possible to get these birth certificates. Um, Moving on to the specific issue which we're discussing today is the fact that there are several instances and there's number of children who are born from Rohingya and Bangladeshi marriages or relationships in general, and I'll come to why I say that word. But there are number of children from these mixed parent marriages or relationships, more significantly from the 1990s. So a number of them are now very old. They're like in their 30s as well. And intermarriage, specifically among Bangladeshis and Rohingyas, was discouraged but tolerated until 2014. So prior to that, you would have to run through a lot of administrative hoops to get these marriages registered. But there was no real de facto or official ban on registering these marriages. But in 2014, the government actually banned these marriages and they came out with a notification that turned registration of these marriages into a criminal offense. And also, this ban had a very harsh retroactive effect, meaning that all previously registered marriages between Rohingyas and Bangladeshis were also considered to be void. And what this meant is that these children who are now born from these marriages or were previously born from these marriages are stuck in a legal limbo. There is no no sort of significant recourse to citizenship or because of the lack of sufficient proof of parentage. And in our experience, we have seen that most of these children are actually born from Rohingya mothers and Bangladeshi fathers, although there are certain cases, a handful of cases where the inverse also takes place. So what the current practice is when such a child is born in the camps, and if the Rohingya mother wishes to include the child into their refugee ration card, essentially the birth notification slips list the father as an unknown or NA or not available. Um, and so what we end up getting is a number of these cases where these children are de facto considered refugees from single mothers. And now, so going on to the law on citizenship and birth registration in Bangladesh, we have the 1951 Citizenship Act, and we also have a temporary order from 1972, which temporally binds this act. Essentially, it's governed by jus sanguinis, which is by descent, and in some cases by migration, but that was also limited to before 1952. The citizenship by jus soli is available if identities of parents are not known, and the caveat that the child is not born from enemy aliens, refugees, or people residing illegally within Bangladesh. And so again, this sort of shuts the avenue down for Rohingya children born from Rohingyas themselves. And citizenship here was historically transmitted by the father, but an amendment in 2009 to the Act meant that mothers could also transmit citizenship. But this amendment was not retroactive, and so children who were born from Bangladeshi mothers prior to 2009 are still not considered citizens. And then the Section 2N and 5.1 of the Birth and Death Registration Act makes it actually mandatory for the state to provide birth registrations for all children born in Bangladesh. And the wording of the act specifically includes also foreigners and refugees in line with Bangladesh's CRC convention obligations. However, what we've seen in practice is that this is not happening. And we have a number of children, obviously Rohingya children, and also children born from mixed parentage who are not receiving birth certificates. But it is important to note that they are actually citizens of Bangladesh by operation of law. And so there is obviously a disparity between what the law says and what the procedure is. And because of this, we're seeing a number of challenges. The first one is if camp authorities know that a child is born from a mixed marriage, then they refuse registration into the UNHCR database. If it is hidden from them, then sometimes they make their way into the registration database. But if not, then they are deprived of rations, education, and other humanitarian services within the camps. Older children from 1990s who are now sort of part of that retroactive marriage ban, they suffer from the problem of double registration. They're now registered in both the citizen and refugee database, which makes it very difficult for them to access various services such as bank accounts, anything that requires a security check, such as immigrating to another country. And parents with children who are born outside of camps, they often have to pay a lot of money to representatives to procure birth certificates. And sometimes if these issues are found out, then they are rejected outright. And now coming very quickly to the issue of courts, courts have been very reluctant to recognize this issue, although we have not filed a direct case challenging this particular instance or situation. We did file a case in 2023 where a child was taken outside of the camps by the father, who was a Bangladeshi, and the mother came to us alleging that the child had been abducted. We went to court with this, and the court actually cited a high court judgment in 2022, which validated the marriage ban and sort of termed it a criminal offense. And so the court refused to recognize that this was a child born from a Rohingya and a Bangladeshi, and then rejected the petition. And so finally, my last point on this issue is the reason why advocacy on this topic remains restrained is there is a lot of government sensitivity on this. The government doesn't really want to engage on this particular topic. And we've seen the courts have often sided with the government. So the time is obviously now still not right to come forward with a case or even a test case. But the UNHCR has done some advocacy. It has submitted to the Universal Periodic Review stating this particular issue, and also came out with a policy brief stating the number of challenges that these individuals face in the Cox's Bazar region. So I think I'll stop there. I think I've taken up a lot of time, and apologies for the disruption in the middle. Thank you.
Thank you so much, Ibrahim, for that very wonderful discussion or presentation you've had, highlighting for us some of the legal provisions and also highlighting challenges such as access to justice on the basis of lack of legal standing in courts due to lack of documentation for children or people born in Bangladesh, their status. Thank you so much. And now I'd like to welcome Yusuf Bashir to give us his experience from Kenya and probably also give us strategies you have developed. I know you filed a case in the High Court in Kenya. Kindly give us what that has been for you and the experiences and strategies you've used in that case so far. Thank you.
Thank you very much, Maureen. Just to give a quick analysis of the context in Kenya before I come to discussions of what we've done and some of the cases that are ongoing. Kenya's approach to refugee management has changed over the decades. And in the 80s and 70s and even prior to that, refugees who arrived in Kenya did not have challenges with regard to freedom of movement. They did not have issues with regard to access to services. The collapse of the Somali state in the early 1990s caused a significant shift in that regard. And this is historical because the Somali government, when it was existent at the time, had claims towards certain parts of Kenya that were occupied by ethnic Somalis, border areas. This presented a challenge when huge numbers of people who are from a neighboring country with whom there have been tensions suddenly arrive in the country. And this shifted the approach from whereby refugees were freely moving around towards an encampment policy. The two main sprawling camps that ended up being established, that is the Dadaab refugee camp and the Kakuma camp, hosting hundreds of thousands of people at a go. The change was that these areas were essentially like huge prison camps, whereby humanitarian organizations such as UNHCR and others were expected to provide all manner of support to these individuals who are in these camps, and they were not supposed to move beyond the camps, in the hope that after a few years, these individuals would again, go back to their own country. But this did not happen. Over the years, since 1990s now, the Dadaab refugee camp has been in existence for over 3 decades now, heading almost to 4 decades. And this has the encampment and the security approach has resulted in a lot of challenges for refugees, both intended and unintended. Unintended consequences, if I start with those, include the problem of double registration, which is well known, and Hakina Sharia has been working on it, whereby local Kenyans would go to the camps and find themselves on the refugee database, and then ended up becoming stateless in their own country because it was very difficult to get off the refugee database, and that even took litigation for that to be removed. The The other unintended consequence is the fact that marriages have resulted, and I think Ahmed, the previous speaker, had also talked about this, because these are human beings living in close proximity for decades. People end up getting married, and the children end up getting on the refugee database because in an area where there is not a lot of access to resources, the resources available and provided by these refugee humanitarian organizations become the only way to survive. Getting on the refugee database becomes a way of, just getting on. And once somebody gets on the refugee camp, now we become double registered, and the vicious cycle begins. Haki Nashiri has been working on issues of citizenship discrimination, not only of refugees, but of various ethnic groups in Kenya, such as the Somalis, the Nubians, and others. Essentially, whereby the Kenyan state treats people of different ethnic backgrounds differently and subjects them to other processes such as vetting. Now, the refugee situation is quite unique because a large number of the refugees in Kenya, over 70%, are from Somalia. And Somalis by themselves suffer, ethnic Somalis in Kenya suffer discrimination. So refugees who are from Somalia will suffer extra discrimination because not only are they refugees, they're also Somalis, and it's easy to sort of pick them out. Now, one of the cases which we have, our approach has been to do litigation, we do research, we do campaigning in order to address some of this discrimination. We've done documentaries, and people can visit the Haki Nashiri website to see some of the documentaries of this work. Litigation has proved a very useful tool in terms of challenging some of these discriminative practices by the Kenyan state, especially since the passage of the Constitution in 2010, which is largely regarded as a very progressive document. For example, it provides for rights for individuals to get citizenship as a result of marriage, and that's citizenship by registration, either as a result of marriage separately and also as a result of lawful residence for over 7 years. So this constitutional prerogative has been limited by the Kenyan Act, which is the Kenya Citizenship and Immigration Act, which conflated two separate tracts of accessing nationality into one. Under Section 11 of that Act, the Kenyan law states that for one to be allowed to be registered as a citizen through marriage, you must also be additionally have been lawful resident for that period of 7 years that is required. But the Constitution separates these two. Ordinarily, this has no effect on other individuals, but it has a specific effect on refugees and refugee marriages. This is because the same act under Section 34 specifies what lawful residence is, and it talks about work permits and other sorts of permits for non-citizens. And the failure not to have this, you'll be deemed not to be lawfully resident. And because refugees don't have these work permits, they don't have any other form of permits, and refugee permits are not considered residence, it has resulted that since the Constitution was passed, and since the arrival of these refugees, there is no documented case of a refugee who is married to a Kenyan who has acquired Kenyan citizenship. And this is because they cannot prove their lawful residence in any way. The only way they can probably do this is to renounce their refugee status, go back to Somalia, apply for a visa, back to Kenya, stay for further 7 years, which is actually a ridiculous thing for somebody who's been married to another person for decades. Therefore, we are challenging the constitutionality of this Section 11, which conflicts these two lines, and it results in the discrimination of these marriages between refugees and Kenyan citizens. We're also challenging the placement of the children of these unions in the refugee database based on the best interests of the child. The case has already been heard, and I think we have a judgment sometime in October. And we hope all submissions and everything have been filed, and we wait to see the outcome. Thank you very much.
Thank you, Yusuf, for sharing your experience and also highlighting the importance of litigation in enforcing the right to access to citizenship for refugee and migrant children in Kenya, and also highlighting the challenges faced by refugee spouses of Kenyan citizens. Thank you so much. And now I want to welcome Umer Gilani to give us more details on inconsistencies in enforcement, particularly in Pakistan, of birthright citizenship, and drawing on experiences working on a sensitive pilot project. Thank you.
Omar, I'm sorry, you can unmute.
Yeah, you.
Thank you.
Thank you, Maureen, for the introduction, and to the Global Strategic Litigation Council and all friends for the invitation. I want to start with the background of the influx of Afghan refugees in Pakistan. Pakistan, in 1978, the Soviet Union invaded Afghanistan. And in the subsequent years of unrest that have followed, which have continued almost continually from 1978 to perhaps 2022, there have been multiple waves of Afghans seeking refuge in Pakistan. And at least in the early stages, in the 1980s, for instance, the government of Pakistan was both quite welcoming to them for reasons of geostrategic reasons, and also because of shared cultural and religious heritage between people. Because most of the people who, not all, but most who came from the Afghan side were ethnic Pashtuns, and Pakistan is also home to vast, number, many millions, tens of millions of them, of the same ethnic group. And there is actually a history of migration which goes well before the British era in this region. So that's the background. If you look at a lot of us in the global south, and especially in South Asia, we have histories of migration. When these people started arriving in Pakistan, they were treated de facto as refugees. But Pakistan is not a signatory to the Refugee Convention. And therefore, the situation was quite similar to what Ibrahim has described for the Rohingya in Bangladesh, that the government accepts them, provides them with refugee camps, provides them with ration cards, provides them with a whole lot of other things, but doesn't accept them as refugees at the international fora. At least, so the UNHCR is supporting them. Pakistan does not have any specific law related to refugees, domestic legislation. So it's the same framework in almost all of South Asia, that you have a Citizenship Act which describes citizenship. Pakistan has, shall we say, three major kinds of citizenship. One by descent, that is the one which is generally honored by the government as well. That if your parents are Pakistani, you become a Pakistani citizen. And up until the year 2000, this was just your father. But from 2000 onwards, if either of your parents was Pakistani, you are Pakistani. And children of that who have inherited their citizenship do generally get it in Pakistan. The other is by marriage. So women who marry a Pakistani man are entitled to it. Men who marry a Pakistani woman, the statute doesn't allow for it, but there is a complex history of litigation. And most interestingly, in 2006, the Sharia court, the federal Sharia court, actually said that this is a form of discrimination which is antithetical to the values of Islam. And therefore, this statute needs to be struck down and needs to be read as if this right of citizenship by marriage applied equally to both men and women. But the government has appealed that decision and has had that decision suspended. So as of now, we only get women marrying Pakistani men. But there, again, the issues are very similar to what Yusuf Bashir, of our friend from Kenya, has described. That the government says, so I'm just, last week I was before the Director General of Immigration and Passports, and he said that representing a woman of Afghan refugee heritage who has married a Pakistani man, and her application is pending for 10 years. We went to the court sent us back to the director to get a speaking order. And the director says that in our case, the good thing is that this woman has actually had an Afghan passport and has continually renewed her visa. But if she didn't have a passport or a visa, the government would not, implement the law in her case. So that's a procedural hurdle. I would say actually a fraud of the statute. That if you don't have a visa, you can't get it. But even otherwise, the one of the requirements is that the government will make you an offer, but the country, and then you have to renounce your citizenship. And the next thing the director told me is that right now the Taliban government, because of its tensions with Pakistan, is not allowing Afghan citizens to renounce their citizenship. So once the renunciation process is stuck, they can't, even though the government gives them an offer of citizenship, they can't get it. Anyways, that's the path number 2. The path number 3, and that's the most promising and the one which is most least honored, is citizenship by descent. By birthright, by birthplace. Every child born in Pakistan is entitled to citizenship, and there are only two exceptions: the children of enemy soldiers in occupation of a certain territory of Pakistan. So if Pakistan gets invaded and the enemy soldiers occupy it, and while in occupation they have children, no, those children won't get it. The other is the children of diplomats who enjoy diplomatic immunity. So these are really narrow exceptions. And Pakistan is one of those very few countries from the British Empire who have not made any substantial amendments to this law. So the exclusions, I do think it is important to remember that a lot of these things are shared heritage of the British Empire. Whether we like it or not, it is, you can't really make sense of the laws that we're talking about without that historical context. The British Empire used to have the principle of jus soli. Every child born in the king's territory is a subject of the king. And then that became translated into every child born in the territory of the modern nation state being a citizen of that state. Britain itself amended it substantially in 1948, perhaps when it saw vast hordes of brown people coming to the British Islands and claiming birthright citizenship. America never could, because this particular feature ended up being constitutionalized. If Trump could, he would do it today, but because this wasn't a statutory law, rather a constitutional law in the United States, they couldn't change it. I understand that both India and Bangladesh have, in the last few decades, made exclusionary clauses for the children of refugees. So the children of refugees are no longer, or illegal, for that matter, the children of illegal immigrants are also excluded from the ambit of birthright citizenship. But in Pakistan, up until now, perhaps most recently, we don't know. There's been talks of changing that law in the last few months, and the parliament is right now quite a non-transparent place. So we don't know what's really happening. But throughout the 4 decades that the Afghans came to Pakistan, they had the right to birthright citizenship. It was just not being honored. Since 2016, we have been advocating for enforcing that right. And we have tried to lobby the UNHCR, the press and the media and the politicians. 2018, actually, the former Prime Minister of Pakistan made an announcement in a public forum that the children of refugees will get birthright citizenship. The Prime Minister subsequently received a lot of flack from political opponents as well as the security establishment, and then subsequently sort of went mum, but he never really renounced his earlier statement. And using that statement in 2020, we went to court, and after a couple of procedural knockouts, we finally got a judgment in November 2021, where the Islamabad High Court accepted our enunciation of the law, but it fell short of passing a writ of mandamus in favor of our client. So it said that the law is that you can have birthright. You do have birthright citizenship for the children of refugees. But in this particular case, we will ask the government to look at the petitioner's case. And that case is still pending because of strategic reasons and our reading of the judicial climate, the political climate in the country. We have also, tried to make sure that we don't have that final decisive legal battle on this question. So we are still in the court, slowly building our case. So the birthright citizenship is there, but it is not being honored for the children of refugees, and that is a major issue. There is no legal justification for it. In the last, I think I would actually want to stop there. I think that is the crux of what I was trying to say. And I would be happy to take any questions.
Thank you, Umer, for highlighting for us how the colonial laws was inherited by Pakistan continue to shape access to citizenship by birthright in Pakistan. And before we proceed, I'd like to note that there are a couple of questions in the chat. We will answer them at the end of each questions, and also there will be a session for us to ask questions orally. So we now proceed to South Africa, where similar challenges have been noted, especially as regards to inconsistent application or lack of regulations to steer forward access to citizenship, especially when the children born of migrants attain the age of majority. I now welcome Thandeka Chauke to take us through the experiences and her strategies in the litigation that she's currently carrying out in South Africa. Thank you and welcome.
Thank you, Maureen, and thank you for providing this platform to have this important discussion. So, as I mentioned, I'm working with the global movement against statelessness that I'll share in this particular presentation. In the South African context, citizenship is mainly conferred by blood. So South Africa follows the jus sanguinis principle. However, there are other pathways that are based on birth in South Africa or a jus soli equivalent of that, but with specific limitations. And there are three of those pathways that I'll highlight. The first being children who are born in South Africa and who would otherwise be stateless, children who are born in South Africa to permanent residents and who've lived in South Africa until the age of 18 years old, and then children who are born in South Africa to migrants, to refugees or asylum seekers, and who have also lived in South Africa until the age of 18. And these laws are quite inclusive on paper, but what we see is exclusion in practice, which I think is a common thread that we're starting to highlight from the different presentations that we've had. And we see that these exclusions persist due to, for instance, gaps in implementation So while the laws provide for these pathways, there are no regulations that provide for the application process. So for someone who wants to walk into a Home Affairs office to apply for citizenship based on the fact that they are stateless and born in South Africa and therefore meet the requirements, there's no application form for that person to complete, which makes it practically impossible to then access citizenship. Where there are regulations, it is common to see that the regulations and what the law prescribes. So for instance, adding additional requirements and making those requirements mandatory. Examples are, for instance, with the permanent residence category, which was then challenged in the Constitutional Court, where the Act said that you needed to be a permanent resident for 5 years in order to then apply for naturalization as a citizen. The Department of Home Affairs' own regulations then increased that 5 years, doubled it to 10 years. And we see it now with applications for children born to migrants, refugees, and asylum seekers, where they have now prescribed that it's necessary for the parents' documentation to be attached to the application. The way they interpret the continuous residence requirements is very strictly interpreting it based on legal residence. And they've even added a phrase to say that you must never have left South Africa within those first 18 years between birth and attaining majority. So we see restrictive interpretation. We see several administrative barriers where people who try to apply get stuck at each stage, from the point of application, where some offices refuse to accept the application to begin with. And from those whose applications have been accepted, they're stuck in the system of waiting for an indefinite period for a final decision. And those who come to the end of the process still struggle then to access the actual identity documentation that certifies that they are indeed a citizen. And then compounded with all of this is the issue of institutionalized xenophobia in South Africa. What you find is that citizenship is conferred based on belief and not based on law. So it's when officials look at you and they consider you a citizen, then you might have success with your citizenship application. But there are challenges with discrimination and prejudice that happen even at the level of the Home Affairs Office that creates barriers for people who are entitled to access citizenship to be able to apply. The Department of Home Affairs has also recently adopted a new policy, a white paper on citizenship, migration, and international protection or refugee protection, which suggests that they actually to scrap those inclusive pathways to citizenship and more strictly to citizenship based on blood, which is going to create a lot of challenges for vulnerable children who are at risk of statelessness. And now, in terms of litigation, South African courts have played a very critical role in clarifying what the state obligations are in respect of the right to nationality and prevention of statelessness, and in terms of enforcing children's rights to citizenship. But implementation of judgments still remains a challenge. So organizations like Lawyers for Human Rights, for instance, have obtained several successful judgments in the course of the past 15 or 10 years, where there has been substantive success in terms of a legal victory. And this is important, but it's not sufficient if that judgment is not then translated into true justice for the person. And what we've learned from the litigation in South Africa is that litigation itself often has to be combined with sustained advocacy to push for broader systemic reform. Partnerships between lawyers, between civil society, with directly affected communities are also very important for the purposes of enforcement and holding institutions accountable. Engagement with regional and international mechanisms, such as the African Committee of Experts on the Rights and Welfare of the Child or the African Commission, can also complement national strategies where we're struggling now with implementation. But most importantly, the lived experiences and the voices of affected children and young people help to reframe these issues, not only as legal gaps, but as real human rights violations. And so now we have there's a case that has recently been launched to challenge various aspects of the citizenship system within South Africa, the law and its lack of implementation. And the strategy around that litigation has been crafted based on these lessons. And the litigant in this application, the main litigant, is Lawyers for Human Rights. And the litigation is happening in partnership or collaboration with an advocacy group of young people who are actually directly impacted by the issues we see with the Home Affairs system in administering the Citizenship Act. And this is called the This Is Home group. And the idea of that approach to the litigation is to ensure that experiences are highlighted in the court process, but also lived experiences provide that momentum for implementation if the judgment is successful. And we hope to actually see some material success in terms of those young people being able to access their documentation and secure their citizenship. And I think in conclusion, my observation from the South African experience shows us that while the law may provide pathways to citizenship, systemic barriers might still remain. And making strategic litigation combined with multi-level advocacy a necessary tool to unlock rights and practice is very essential. But also remembering that litigation itself is just one tool in the toolkit that we should be using. Thank you.
Thank you, Tandeka, for highlighting or underscoring the importance of advocacy and litigation as a tool of enhancing access to citizenship. Thank you. And I now welcome Young Sil Kwan to take us through advocacy efforts for policy reform to support migrants' children's access to citizenship. I know Tandeka and Ibrahim had talked about it, but we'd like to hear more from Young Sil. Thank you and welcome.
Thank you. I would like to share my slides. Is that okay?
We're not able to see it yet.
Okay.
It says you've started screen sharing, but we're not able to see your presentation. Is it just me, or perhaps it's just me? Oh, yeah.
Is it working now?
Yes, we can see it now.
Okay.
Thank you.
So thank you. I'm Young-sil Kwon. I'm pleased to share Korean situation. So I'd like to talk about three main issues in Korea. So first, the absence of the universal birth registration system. And second, the problem of the nationality acquisition for the children born out of wedlock to Korean father and a foreign mother. And third, the situation of the undocumented migrant children. So first, Korea does not have the universal birth registration system. Only Korean nationals can register birth, meaning there's no system for the foreign children. Registration through the embassies is expected, but in many cases, this is not possible. For instance, if the parents are refugees or if the embassies is not in Korea, or if the families are undocumented. So this problem has been raised for many years, and at present, three bills have been proposed in the National Assembly, and I was involved in drafting one of them. So we have formed a network for the universal birth registration. Many child advocate NGOs and migrants NGOs and public interest engaged. And together we've been lobbying and campaigning for the change. And now there's growing recognition in public, and we are quite hopeful that this bill will pass in this session. Next, regarding the children born out of wedlock to migrant woman and Korean father. In such cases, the child may acquire Korean nationality through the paternity acknowledgement procedure, but this process can be complicated. First of all, because we do not have the universal birth registration system, and secondly, it becomes difficult when the mother is legally married to someone else. The child is presumed to be the child of the husband by law, and it requires court decision to disapprove it. And additionally, the required documents varies by the mother's nationality, but the Korean government does not really provide the country-specific guidance. So, for example, the government requires child's passport as a part of this acknowledgement process, but countries like China do not issue passport to the children born overseas. And similarly, when the mother is from Malaysia, the child cannot acquire Malaysian nationality, but the government does not really guide them. And also, if the mother is undocumented, she can technically get a visa to raise her child, but there's a high fines for her undocumented stay, and this often becomes unrealistic. So there's ongoing efforts to waive these fines and grant the mothers work eligible residence and to simplify the process of this paternal recognition. And lastly, about the undocumented migrant children. So before 2020, undocumented youth were routinely issued deportation order after high school. And in one case, I represented a youth born and raised in Korea, and he faced deportation after graduation. And on this litigation, we fortunately won, and the court ruled that deporting someone like him who had only ever known the Korea as home country, this violates the constitutional principle of human dignity. So after this court decision, the civil society gathered and pushed more harder for the regularization path for these children. And we conducted like national survey and we filed a petition to National Human Rights Commission. And the commission recommended the Ministry of Justice to create formal pathway for these children. And also the commission helped a quite well-known Korean author to publish a book based on the interviews of these migrant children, helping them bring a wider public interest, public attention to their stories. So after these efforts, the Ministry of Justice in 2021 introduced a temporary policy to grant them a student visa. But it only applies to those who were born in Korea and lived over 15 years. So this is quite difficult criteria. So we've been criticized, and it was relaxed in 2022 to include the children with who lived in 6 or 7 years, even if they are not born in Korea. And this policy was extended again recently. It now allows youth to, actually they had to be enrolled in university to get this visa, but now it changed it to they can get the employment visa after high school as well. But still, it remains as a temporary measure. It's not in law. So we are working with the National Assembly to draft an amendment to the Immigration Act to regularize this policy. And we've been also working for the international human rights system. Recently, I went to Geneva to participate in Korea's review by the UN Committee on the Elimination of Racial Discrimination. So this third recommended the Korea to review its law to allow migrant children to stay legally and acquire nationality. We hope through these efforts, we can bring some meaningful changes. Thank you.
Thank you. I think by now we are able to see how legal different countries adapt different pathways to access to citizenship. And now we want to draw in from Zambia. And I welcome Isaac. to give us the Zambian context. I understand that you had initially tried to do policy advocacy before filing a case at the High Court, and therefore we'd like to hear more about that. Welcome, Isaac.
Thank you very much, Maureen, and the entire team. So, Zambia basically, for citizenship in Zambia, it's anchored on the Constitution of the Republic of Zambia. It is a principal law that provides for citizenship of Zambia. And under the Constitution, we have 4 categories of citizenship, which include citizenship by birth, citizenship by descent, registration, and adoption. But our Constitution also allows dual citizenship. It's when we amended this Constitution in 2016, we now allow dual citizenship. This is a progressive move that we believe would allow those that who still want to retain their identity from other countries, but also apply for citizenship to be able to Zambian citizen to be able to acquire their citizenship. And indeed, our citizenship is primarily that must be you become a citizen of Zambia if you are born from a parent. One of your parents must have been a citizen. That is the key in this country, and that provision also allows you to become a citizen if you're a child who was found in Zambia and was less than 8 years at the time that had been found in Zambia. So it allows you to be regarded as a citizen by birth. We have the citizenship by registration. This is a very key category of citizenship, and this is one where refugees would be allowed to apply and acquire citizenship. I must be quick to mention, however, that there are a number of laws that interact in Zambia when you talk about citizenship in this country. One of them is the Refugees Act of 2017. Another one is the Immigration and Deportation Act of 2010. Another one is the Children's Code Act, number 12 of 2022, which provides for the right to citizenship. Now, you appreciate that before 2016, there was no opportunity for refugees to acquire citizenship in this country because the law did not allow refugees to acquire citizenship. But with the enactment of the Refugees Act in 2017, which has domesticated the international conventions, the 1951 convention, it also domesticated the 1969 OAU, Organization of African Unit Conventions on the aspects of refugees, the problems that have to do with refugees. With that domestication of these international instruments, it opened up the opportunity for refugees to apply to become citizens. As of June 2016, when we launched our petition, Zambia had 103,000 refugees. And out of these 103,000 refugees, you'll find that 17,000 of them are former refugees, those who have been affected by the cessation clauses which was invoked by Zambia in 2012 and 2013. These are largely coming from Rwanda and Angola. The Angolans are the majority. Then we have the Rwandese. These are former refugees who, under the Act now, under the Refugees Act, are entitled to be naturalized because the Act has provided for naturalization of refugees. Those persons who have ceased to be refugees, they can be naturalized by the Minister of Home Affairs. Whether that will happen or not, it has not been tested. I think the issue has been the implementation in Zambia. Nobody has been naturalized so far from 2017 up to date. So we're actually a very good country when it comes to the law. Our laws are very good. Our country is very progressive with the law. And in terms of policy as well, this new regime that we have under President Hakainde Hichilema, they've come up with a policy called the National refugee policy, which was accepted by cabinet in 2023, which now coordinates the way refugees affairs are going to be managed in this country. But at the same time, we have not seen any progress in terms of granting refugees citizenship because of the legal barriers that are inherent in the law itself, subsidiary law. So whilst the Constitution itself, under Article 37, provides for refugees to acquire citizenship, and also the Refugees Act also allows refugees to acquire citizenship, which will lead them to lose the refugee status. That has not happened. The subsidiary law has made it very difficult for refugees to acquire citizenship because of the Act of 2010, the Immigration and Deportation Act of 2010, which does not allow refugees to acquire the permanent residence permits, which is a prerequisite under the law now for anybody who's not a Zambian, who's a foreign national, to apply for citizenship. So we have this old law, which is the, you have the Constitution 2016, you have the Citizenship Act 2016, before the Domestication of the Refugees Act in 2017. Now, these laws that were enacted before the 2017, except the Constitution, they have made it difficult for refugees to acquire citizenship, primarily because there's a requirement that every person who's applying for citizenship must have a permanent residence permit, which is only issued to regular migrants, and the refugees are irregular migrants. They do not come here like any other migrant who comes into this country. So they are not entitled to this. There was a policy shift under the previous regime where the Republican president had issued a decree that refugees must be given permanent residence permits, but that is not backed by any law at all, and we see that government has not continued with that process. So we tried to engage with the Zambian government before between 2022 and 2024 to try and discuss the question, try and move the government to begin to grant citizenship to refugees, especially former refugees, whom the Refugees Act allows the minister to naturalize them. But also to begin to talk about these children of the born from refugee parents. So you may have children that are born from a parent who's one parent is a Zambian, another parent is a refugee. They are born from these parents, and they have a challenge to register these children as Zambian citizens when the Constitution allows them to be registered on the basis that one of the parents is a Zambian. But also, generally, these children who are born from both parents who are refugees, but they have been born on the Zambian soil. Our law, our constitutional law states that these children, when they reach the age of 18 and they've been residents in Zambia for a period of 5 years, they should be able to apply for citizenship. Now, the challenge is this, that we have categorized these children to be refugees themselves. Even if they have been born in this country, you have a policy where government categorizes these children to be refugees, when in actual sense, both our law and international law would not categorize them to be refugees because they never ran away from anywhere, from any persecution. They're in a situation where they found themselves in this country because they were born on this soil. And they know no any other country as their own, except they acquire the status, the legal status of their parents. So if you are Angolan, they'll say you're Angolan, but to classify you as a refugee, making it very difficult for you to apply for citizenship at some point. We register them when they are born. Yes, Zambia has a law that allows the children that are born in this country to be registered and to be given certificate of birth by the Department of Civil Registration. And our belief is that these are the documents that are needed for these children to apply for citizenship when they reach the age of 18. Because when they reach the age of 16, they're still issued with a national registration card, which is different from what is issued to the Zambian citizens by birth. It will have a different code for foreign nationals. Regardless, they are required to apply for citizenship, but I've seen them not apply for citizenship. So there was a lot of engagement between ourselves and government to try and regularize this issue of refugees. We went to, when it failed to, at the executive level, to engage the executive. When it failed, we tried the parliamentary route, where we said we need to deal with the issue of the residence permit, the requirement of the residence permit, which is against the Constitution. It does not speak to the Constitution. The requirement for a permanent residence permit does not speak to the Constitution because it modifies a definition which has been provided in the Constitution. The bill went through Parliament, and unfortunately, it was not supported at second reading, so it failed at second reading. The failure of that bill is what has now led us to court to try and ask the court questions on whether the Constitution indeed allows our refugees to acquire citizenship, in view of the barriers also that we see from subsidiary law. Our hope is to ensure that the Constitutional Court wants to interpret that the children who are born in this country from parents who are refugees are not refugees, and that they're entitled to apply for citizenship. That is going to open a way for them to begin to apply for citizenship in this country. And these are there are about 33,000 of them out of the 103,000 children that have been born on this soil. Some of them, before even we became a country called Zambia, they're still being regarded as refugees in this country. So all of them, there are about 33,000 out of the 103,000. So we have asked the court to interpret constitutional provisions, but as we have also asked them we have challenged the constitutionality of the definition of ordinary residents in the Citizenship of Zambia Act, which is, we believe, is inconsistent with the constitutional definition. Now, the effect of that is that if the court is going to determine that the definition of ordinary resident has amended the constitutional definition of ordinary resident, including the requirement of a permanent residence permit, and that definition is back from our statutes, it means that we would have made progress, because now there will be no requirement for persons who have a permanent residence permit for them to apply. As of 13th of June, which was some 2 days ago, this matter came up in court. There was an application by the Global Council to join as amicus in this matter, and the Global Council was joined by the court as amicus in this matter on the 13th. And for the main hearing, the parties, the Attorney General, the state, and ourselves, we agreed to, we have been in discussion, because literally our submissions are agreeing with each other to say that children are entitled to apply to be registered, considered and registered, as well as the former refugees are entitled to be nationalized and acquire their Zambian citizenship. So with the differences that we have, they've been narrowed now as to at what point can a refugee apply for citizenship. These are the issues that we are trying to sort out, and they probably look at an amicable solution. If we fail to get an amicable solution, the court has only given us up to September, which is the beginning of the next session, the next hearing, to see if we're able to reach a compromise and then we could withdraw it if the state begins to grant citizenship to parents of these children and also to the refugees themselves. If they're able to grant them the citizenship, allow them to apply so that they can be considered, then would have achieved part of the goals in our litigation. Otherwise, I think these are some of the issues that I thought that we could highlight. So our litigation, our strategy has been a three-phase strategy where you engage with the executive. If you fail the executive, you go to parliament. When the parliamentary route fails, you now go to the judiciary as the last point. And that is where we are. And we are going to continue with this path, depending on the outcome also of the court decision. We know that it will be very impactful because of the materials that have been put and on the record. We might not get everything that we want, but at least the bigger part of it is that there's an agreement between the state and ourselves in our submissions that the refugees are entitled to citizenship and that the children who are born in this country are entitled to citizenship. So with that pronouncement, we can begin to test the law by allowing the refugees to go and apply. Those that are denied, we can now begin to use the high court system to challenge the denial of the registration for refugees as citizens. So our laws generally are very good. We're a good country. We make very good laws, but the problem is the implementation of these laws, like any other country. Thank you, Maureen and Nadine.
Thank you so much, Isaac, for those very insightful comments from the Zambian situation. And just in wrapping up this conversation, I would like to welcome Dr. Manby to give us his closing reflections, drawing on his personal insights and key messages from the guide for practitioners, noting that litigation and advocacy strategies are very useful tools for enhancing access to citizenship. Welcome.
Thank you very much, Maureen, and welcome everybody. It's good to be here. It's very striking how many commonalities there are across the different presentations and across many of the other situations I'm familiar with as well. I'm in particular the fact that even if the right to citizenship based on birth in the territory is there in law, in a big political struggle to make that happen, or alternatively, it's a legacy from Britain in 1960 or 1948, I guess, 1947 Pakistan, but legacy of that British system. You cannot get it implemented in practice. And I was particularly struck by the Pakistan context. So in Africa, Tanzania and Lesotho still have the same provisions. Child born in the country is a citizen unless neither parent is a citizen and one is a diplomat or it's an enemy occupied territory, exactly the same provision. But because of the extremely convoluted way it is drafted, the government just says, oh, well, there's a full stop after that. We'll forget all that. And it just says, unless neither parent is a citizen, and stop there. And that, it's not possible to litigate that in Tanzania at the moment. Courts are not free enough. It's a repressive environment. But I do wonder if one might be able to litigate that point in Lesotho, because the law is absolutely clear. And Tanzanian immigration officials have agreed with me privately that the law is clear as well. But there is nonetheless an official opinion of the Attorney General in Tanzania from 20, 30 years ago saying that the law does not say what it says. And that is what is applied. So Kenya as well had that provision, just solely citizenship in Kenya, and then it was the law and the constitution was amended in 1985 with retroactive effect, which is absolutely shocking as a matter of the rule of law. So in principle, everybody born in Kenya between 1963 and 1985 should be Kenyan. I'd be interested to hear from Yusuf if it's possible to litigate that, or just too politically difficult. Start nibbling at the edges and see if you can get further in as you go. Another just point of reflection is that access to naturalization is almost impossible, generally, actually, for other migrants, but especially for refugees. In most of the sort of what I can describe as post-colonial environments. So across Africa, Nigeria, let's call it 200 million people for the sake of argument, since nobody knows, but more than 200 million probably. A couple of hundred people or less are naturalized every year. By comparison, Britain, 68 million, and it's 150,000 or so who are naturalized each year. Now, the British tendency is very negative as well, but nonetheless, naturalization is accessible. And I think that question of a combined, kind of cross-country push, as a word to say, that naturalization should be accessible. I mean, South Africa has reversed that. So South Africa used to have, until about 2010, several thousand naturalizations a year, and they're down to a few hundred now as well. And obviously there are political constraints there, but there are also just rule of law principles about for how long are you going to say that somebody is not from here. Another common theme which I'd like to hear about, it's more in my mind rather than what was said, but I would be interested to hear from people about the challenges of consular access. Again, Umar talked about that in the context of an inability to renounce Afghan citizenship. But it's often the case with birth registration, for example. So let's say the child of a refugee wanted, in fact, to claim, a child of a former refugee, for example, wanted to claim the nationality of the parent because they're blocked where they are. You would require, normally speaking, formal birth registration in the country of birth, already a challenge. And then you have to take it to this embassy to get it officially transcribed or recognized by the embassy for the records of the country of origin. That process is almost totally inaccessible. And if you are currently still a refugee, you may in fact undermine your entire refugee status by even approaching the embassy. So there's a whole challenge there on which there is no international guidance and little litigation at national level, because states just say consular assistance, discretion, nothing to see here, we cannot even have a discussion. And I'd be interested to hear from people about that. Just to conclude really with some thoughts about rising from this discussion, and with reference particularly to the guide on litigating the right to a nationality published last year, which I will just hit enter and send that, send the link. The guide has two main sections. It's long, it's not bedtime reading, it's a detailed reference guide. Half of it is strategy around litigating nationality, highlighting in particular that people who are not nationals and who may be stateless are a particularly vulnerable group of people. Often, really, first of all, it may not even be possible for them to have legal standing before a court. Secondly, even if that is possible, the actual litigant who is named in the litigation needs to be a person with sufficient protection, sufficient confidence in their legal status in the country that they are prepared to be visible in that way. They're often deeply unpopular, or alternatively, as well, politically sensitive, because electoral balances may be changed in particular parts of the country, or generally if a large group of former refugees or irregular migrants are regularized and given access to citizenship, and so forth. So there are real challenges. So the guide talks about strategies to overcome some of those challenges. And then the second half of the guide is a legal argument, trying to provide resources from comparative national courts, what different courts have said around the world, but also from the regional and UN human rights systems. And I should just say one of the main challenges in the Asia-Pacific region is the lack of a regional human rights system. Not that a decision of the African Committee of Experts on the Rights and Welfare of the Child is implemented just like that. Of course not. But in Kenya, decisions of both the African Commission and the African Committee of Experts have been really pivot points for advocacy around improving the situation in the country, even though the recommendations have not been fully implemented. They've nonetheless created space for a discussion and for additional advocacy. But just a final thought, I mean, one of the points emphasized in the guide is just the question of framing. What is the problem that you are talking about? And in the context of international advocacy and litigation, very often it's the word statelessness that you reach for. And that can be a very powerful advocacy tool. Are these children stateless? Are these people stateless? Are these former refugees who have lost any connection to Angola and live in Zambia, are they actually stateless? And that can be a powerful advocacy tool. But it can also be a word that says, well, I told you they were foreigners. We don't have to do anything with them. They're stateless. They're UNHCR's problem. They're not our problem. And so that question of what is the problem that you are talking about? And, I see, clearly that the litigation that is going on amongst the other panelists here is taking account of that. So are we talking about the right to birth registration? Let's say the legal identity of a child and the importance of the connection of the child to the parents. We're not talking about citizenship. We're just talking about the family unit and the importance of that recognition. It's a first step. Are you really saying that this father cannot have the right to interact with his child as his own child? Is that really what you want in this world? So that type of presentation. There is also the question of sex discrimination. I was fascinated to hear that a Sharia court in Pakistan had ruled that discrimination in marriage was unacceptable, because whereas there's been quite strong progress on discrimination in transmission to children, discrimination based on marriage remains much more common. And I was very interested to hear that. I sort of feel like I should sneak that into the next edition of the guide, if there is one. But in the end, there is the right to nationality. And I liked very much Tandeka's presentation from South Africa, working with a group of children incorporated or presented under the title, "This is Home." And I think that's, in so many contexts, in fact, are you telling people to go home to a place they've never been to, where their parents may never have been to either? And I think, when it comes down to it, "This is home" is a very fundamental piece of messaging. And the last thought is that, litigation is, of course, as we would all recognize, only one part of this puzzle. It has to be a multifaceted type of advocacy. But litigation can unlock certain types of conversation that are not available in other spaces. And I'll conclude there. Thank you very much.
Thank you so much, Dr. Manby, for beautifully wrapping up for us the panel session. I'd now like to welcome Nandini to take us through the question and answer session. Thank you.
Thank you so much, Maureen, and thank you, Dr. Manby, for sharing your insight on the guide on how to use practical strategies to address the challenges that we've all discussed today, and also for bringing in perspectives from other jurisdictions. And also thank you so much to all the panelists. You not only highlighted the many legal and systemic challenges that refugee and migrant children face, but also you've shown us what it means to confront these challenges through strategic litigation, policy reform, international advocacy, and even engagement with those with lived experiences. As Maureen said, I think we'd love to move on to the next part of the session. We are really hoping for some engagement from our participants over here. As I indicated earlier, in the spirit of true collaboration, we really invite you, our participants, to complement and deepen this conversation. So this is an opportunity to bring about your perspectives, practical insights, even questions that could help us collectively strategize going forward. I see we have a raised hand by Malon. I hope I'm pronouncing your name properly. I can just 1 minute. I can give you speaking permission if that's all right.
Thank you very much. My name is Malon Muronzi from Zimbabwe, a youth environmentalist and a youth climate change activist. This is a very insightful conversation. I'm also a human rights defender, migration rights defender. So this is a very insightful conversation. I wanted to ask the presenter specifically, Maureen from Kenya, if I'm correct, how best you can try to work or talk about or protecting the rights of migrants, specifically those who are behind bars. We have an escalating situation in Zimbabwe that is currently trending. some refugees, they are behind bars. Some of them, they don't have they don't have them identifications, what you call national IDs. Some they don't have births. Some even they are illegally detained in those remand prisons. How basically try to protect those people, especially the rights of the immigrants, the rights of the refugees, those who don't have the national identities, birth certificates, so that they also can claim to be citizens of a country. Lastly, the question is, how best can we try to empower those people? Soon they come out of the behind bars, or some of them they've been illegally detained. How best you can try to present the rights of the refugees? Thank you.
Thank you.
Thank you very much, Malon. I'd like to invite Yusuf to help me answer that question. Thank you.
Yusuf, are we audible? I know this is a little bit of a short deviation from the topic, but maybe Maureen, maybe if you just want to answer it really quickly while Yusuf becomes available.
Yeah, thank you so much. I think in Kenyan context, for refugee behind or migrants behind bars, the Kenyan constitution provides for rights for everyone in the country. And I think the right to a fair hearing, the right to procedural aspects of it, where your rights from the point of arrest to the point of detention. So the Constitution of Kenya is very elaborate as regards to protection of everyone's right in Kenya, including migrants, and particularly as regards to those who do not have documents, illegal or irregular migrants. The Constitution, as regards to being arrested and detained, the Constitution is very clear and provides mechanisms under which when you're arrested, your rights as an accused person, whether you're a migrant or not, are protected. Thank you.
Thank you so much, Maureen. We have another raised hand. Participating in our conversation. Hello, Victor. I think you should be able
Yes,
to.
thank you.
Yeah.
My name is Victor from Kenya. I work with HIAS, and I wanted to contribute to the question asked by our colleagues, and from the perspective of what I've seen taking place. Organizations do what we call detention monitoring, where they go across some, detention centers to identify if there are migrants or refugees really in need of legal services. And you screen them out, of course, to identify what was the issue. You peruse the court files, the police files, and if you identify a person who is in need, of legal services, then of course you can move to court, as you watch brief, because mostly in matters against, in criminal matters, they are prosecuted by the government or the state. But again, you can move in to watch brief and request that some of the documents by these individuals are presented in court. Of course, after verification from the issuing agency, that is the DRS, the Department of Refugee Services, and UNHCR. So basically, mostly that is what happens. And I've seen most legal organizations do use that approach. And we also conduct, trainings for the court users to ensure that, when these individuals are presented in court, they are able to reach out to the relevant agencies, even, before they are taken to custody. And previously, I saw that work a lot where a magistrate could come across a case where they feel this is a person who needs legal representation from, the human rights organizations, and they reach out to the relevant agencies, and these individuals are supported. So that is what I wanted to add. Thank you.
Thank you so much, Victor, for stepping in and clarifying the previous question further. I think there were some earlier questions for Yusuf that we can address right now. Oh. I'm just going to give speaking permission to Chance. Bronwyn, is there anything? Sorry, I just saw your raised hand.
Yes, no, I thought I would just chip in on this question of migrants, refugees behind bars from our colleague from Zimbabwe. I mean, one of the contexts in which people can find themselves in detention is outside of the criminal context, but in the context of country, where the person is resident wants to deport them to the country where they say they come from, and they have no papers, no connection there. And again, and indeed they are stateless. They may have been born in another country, but they have no documents from there. And the whole question of stateless people who spend months and possibly years in detention, or possibly being arrested and put in detention and then released because there's a time limit or because nobody knows what to do with them, and then they're rearrested and put back in detention. That is a huge issue. There is some advocacy around that. So the European Network on Statelessness has a number of resources around stateless people in detention. So that's especially people in the migratory context. So there are, and there are some resources on the UNHCR website as well. But that's the context where people who are irregular migrants, but very often we are not talking about people who are irregular migrants. We're talking about people who are born and raised and are living in the only country that they have ever known. So they are not in any sense migrants, but they are treated as irregular migrants. And so that is clearly a whole idea. And I think there's sort of scope for litigations. So there is, for example, in the UK, if you are born in the UK, you have the right to acquire citizenship after 5 or 10 years, depending on whether your parents were legally resident. The challenge has been made to make it incredibly expensive. So it's £1,000 per child. But nonetheless, it is a question of right. But in addition, even if nobody's ever made the application on your behalf, you can't be deported because if you're born in the UK, you cannot be irregular in that sense. So you can have your life can be made extremely difficult. But there are, in absent, for example, a criminal offence, there should be efforts to try and regularize your situation. But that is, it's a really tricky situation, that one, around which there, in many different countries around the world, but there are some resources available.
Thank you so much, Bronwyn. Yusuf, I saw that your hand was up if you want to contribute. There were also a few questions for you, so perhaps you can answer those as well later. I can read them out to you, but please go ahead.
Yes, I wanted to comment. I think there's a question that has been asked about the new Refugee Act in Kenya, and what my comments are on that, because I think it's a very relevant question. I think the main challenge with regard to the encampment policy that I mentioned in my presentation is that the freedom of movement of these refugees is extremely curtailed for decades. Now, this with the reduction in donor aid globally, and the fact that refugees no longer are getting the rations they were getting before, with the Americans changing their mind on a lot of things, then the integration of refugees and giving them the right to access entrepreneurship opportunities becomes a very vital thing. And the main hurdle to this process of integration is the lack of freedom of movement. And the Refugee Act in Section 28, for example, identifies the refugee identity document to be at par with the documents that are held by regular foreign nationals who are in Kenya. Regular foreign nationals who are in Kenya have the right to move around, they have the right to engage in businesses where they have the right permits. So there is this sort of disconnect between the actual provision of the Refugee Act, which recognizes that the refugee ID card shall be sufficient for purposes of identification and access to government services, at par with the documents that are held by foreign nationals. At the same time, the refugees are still locked up in the camps. So there's this issue that currently exists, and there's seemingly no solution. And I think there's inevitable litigation that's going to happen around this issue of freedom of movement, because the courts have already pronounced themselves on this. But there's a failure on the part of the Kenyan government to be able to actualize this obvious rights that the refugees have. I wanted to comment on that.
Thank you, Yusuf. Ibrahim, if you want to go ahead, I see you have a raised hand as well.
Yeah, I just wanted to chime in on this conversation with Dr. Manby and Malone as well, in terms of detention of refugees or stateless persons. So in our situation in Bangladesh as well, I mentioned that refugees who are registered with the UNHCR, they are granted that kind of prima facie humanitarian residence assumption. But beyond that, others who are found in other territories of Bangladesh are actually detained and sentenced under the Foreigners Act. But then there's this huge problem of where do you send these people back once their sentences are over? And we had a number of cases where refugees or Rohingyas were languishing in prison for up to a decade. And in two cases, we received a very ridiculous judgment. The first one in a lower court in a border district where the judge actually ordered their deportation back to Myanmar and asked the government to identify, or even in case there isn't one, to sign a repatriation treaty with Myanmar. And so this was, at that time, obviously, it was taken very negatively. And based on that, challenge was made to the High Court, centering the issue of another Rohingya person who had been languishing in prison for 12 years. And there, the court did something really interesting. It engaged in a nationality determination within its judgment. And in that judgment, the court, and I quote this from the sort of verbatim from the text, is that though the individual is a citizen of Myanmar, but the government of Myanmar is not ready to accept him, and therefore he has no recourse to return. And so it was interesting to see that the court actually had this piece ready where they straight away determined that this person was a citizen of Myanmar, but they did not actually investigate whether the law of Myanmar at that time conferred citizenship on this individual. So there was this line where they said that they are a citizen, but they cannot be accepted at this time, and therefore they should be sent to the UNHCR camps. And so there is this very, very sort of weird quasi-legal standing from the courts that we've gotten. And this applies again to all such cases where we have issues of arbitrary detention now. What we usually end up doing is we go to court with this high court judgment saying that, they should be released and sent to the refugee camps. So there is that sort of interesting judgment from the High Court here in Bangladesh.
Thank you for adding that, Ibrahim. Isaac, you also have your hand raised. Perhaps you can go next. And I know Chance, who's a participant, he's also raised his hand for a while, but we'll come back straight to you after Isaac. Please go ahead, Isaac. Thank you.
Yeah, so I just wanted a quick one, just to add that indeed this issue of detention of refugees is an issue almost everywhere here in Africa, especially in Africa. And in my country, Zambia, for instance, the Commissioner for Refugees is responsible for protection of refugees. And when refugees are detained, we have had situations where the Commissioner for Refugees would intervene and ensure that these refugees, who are genuine refugees, are released from custody. But the challenge which is there, of course, is the issue of the office is not centralized to provinces and districts. And where refugees are, especially in the provincial centers, the urban centers, you'll find that they're just saying that they're just told go before the court, plead guilty. When you plead guilty, you're fined. Sometimes without even understanding the proceedings because of the language barrier and all that. So the intervention that we're trying to make as well is just to set up a refugee legal aid clinic where we can pilot in the three provinces in Zambia to see whether we can have pro bono lawyers to ensure that they can attend to refugees that are detained, that needs representation in a very good time, short time, so that we do not have these arbitrary detention. But we also understand the global the pledge that was made at the Global Compact, which was a common pledge against the detentions of refugees, finding the alternatives to detention of refugees, which was supposed to be on the taking care of the rights of the refugees. So with those interventions, international interventions, we are trying to ensure that we actualize those pledges in our country by trying to work closely with the authorities. And of course, it's not easy to work with the authorities that the refugees themselves. But I thought I should just add a context to say here in Zambia, it's a commissioner for refugees who's supposed to protect these refugees. But non-state actors like the Zambian Civil Liberties Union are also trying to scale up the efforts to protect them. Thank you.
Thank you so much, Isaac. And as promised, Chance, if you can hear us, and if you'd still like to make any contribution, please go ahead.
Okay, so hi everyone. My name is Chance Owera. I am a former Rwandan refugee from Zambia, probably, if you were to put it in those lines. I was born and raised in Zambia. I am a lawyer with a particular interest in immigration and refugee protection. So basically, what we find possible and to protect both the refugee community and the immigrant population in Zambia. So mine is a contribution because I can see that most of the issues refugees pass or go through have already been discussed by a lot of the people that are on the panel. So I was speaking to one of the guys from UNHCR yesterday in light with one refugee day, which is supposed to fall on 20th of June, 2025. And something caught my attention with the information that I received from this UNHCR official. And she said, and I quote, she was like, global funding has been cut. So most of the projects that we were supposed to undertake as UNHCR have been shut down. And specifically, I asked if the roadmap to implementation of the refugee policy, which was launched in 2023 in Zambia, is one of the projects that has been shut down, because I looked at the roadmap and in light of that, the roadmap was supposed to be completed this year. So the refugee policy was supposed to be launched this year to be able to support the Refugee Act, because the Refugee Act does not necessarily incapacitate some of the problems and some of the legal challenges that refugees go through. So as Mr. Isaac said, most of the laws in Zambia necessarily don't have problems. Usually, if you look at the constitution is fully recognizance of refugees as a whole in the community. But the problem comes in with these other acts that necessarily don't follow the constitution to the core. In light of UNHCR's alleged statement of them being cut in terms of funding, don't you think that civil societies and probably well-wishers of the refugee communities or defenders of refugee rights needs to come together at this time? Because looking at the situation in Bangladesh, looking at the situation in Korea, looking at the situation in Malawi, looking at all of the global situations of refugees in the world, don't you think that it's time for us as sympathizers, empathies, and the community at large to be able to support these refugees in one way or the other? Others might not be so privileged like I am to have attended tertiary education, because in Zambia, I'll be honest with you, it's very hard for refugees to attain tertiary education. Even accessing basic commodities like medical aid is quite a difficult thing for refugees to access. So don't you think that the global community should find other means as opposed to going through UNHCR? Because we've seen it countless time and time again. UNHCR always has a limit as to where we can reach as an organization. And we thank them for that. But then what are we that are outside UNHCR doing to contribute to the sustainability of the refugee community? Because at the end of the day, the end goal of the refugee community is for them to be able to sustain themselves in the countries that they live in. Be it through integration, be it through neutralization, be it through resettlements or any other mechanism that might help them survive, there should be an end game that is sustainability at the end of it all. And seeing that everything is now crashing down, with US aid crashing down, with UNHCR complaining that its funding has been cut down, don't you think it's important for us as a global community to come together and try to figure out other things that are supposed to support refugee policy implementation, number one, and sustainability of the refugee community? Thank you.
Thank you so much, Chance. Unfortunately, your connection was, I could not understand the entirety of your comment and question because there were some disturbances in the middle. But Bronwyn, given your global experience, would you like to take this one?
Oh dear. The UNHCR's cuts in funding, it's US government funding was, I think, between a quarter and a third of UNHCR's budget. There's nothing we can do about it. I don't know what more there is to say. It's we could all do our historical critique of USAID, but this wasn't quite the initiative we had in mind. So I don't know what to say. It is, of course, extremely difficult. All we can do is carry on with the resources we have. I actually have nothing very substantive to offer. Congratulations on managing to, acquire tertiary education yourself and battling through that. All we can do is, in our individual cases, do what we can to resolve that situation. But I'm going to hand over to Umar because he has a solution.
I don't really have a solution, but I think I like what he's saying, which is that we need to have a normative framework, which we advocate for, because a lot of the lawyering that we're doing is just tweaking at the borders. But there is, I think, no harm, perhaps some utility to having a serious conversation about why we have come to this position. where the nation states that we live in are not even willing to abide by their own laws when it comes to people who have come to that country at some point in history from outside the borders of that country. So this sort of sanctity that we attach to the nation states, I think, is something that is fundamentally at odds with the ideals of the rule of law or of human rights. So if you were not of born to Pakistani parents, but you have lived here for 45 years, and your parents have also lived here, let's say, since they were toddlers, just the fact that you don't have a paper issued to you by the Pakistani National Database Authority saying that you're a Pakistani, you can be picked up, sent across the border, and no one cares. That's a moral problem. It's not just a legal problem. I think we really need to think it is connected with a lot of other ideas, which the moment you start examining them seem to be rather absurd. I mean, why is it that we have locked up humanity into these, these borders, and their humanity, if you're not accepted as a citizen or a valid migrant by the government of that country, we have given them even the right to invalidate your marriages. So, this idea that marriages can be invalidated, uh, you can retrospectively take away citizenship, and then by virtue of that retrospective stripping of citizenship, also invalidate someone's marriage. I think this is rooted. The problem is that when you give states that much power over the people who live in it, and that much normative power, positive law is given that sort of normative power, then these problems are inevitable. So I think we have to look at that idea of universal human rights, this idea of natural rights for that matter. You also have to explore into. So the refugees who have survived in Pakistan have not primarily survived because of the goodwill of the Pakistani state, or for that matter, the implementation of Pakistani secular state law. It's actually because of this community shared Islamic and Pashtun tribal sentiment, that they could see the humanity in these people. For 2 million, for 40 years, these millions of people were treated as human beings, not because the law said that these people are entitled to rights, but because people could see that there are ties of that they are people could relate to them both as Muslims and also as Pashtuns, um, and perhaps generally as South Asians. So we have to draw on those primordial and perhaps universalistic traditions of compassion and brotherliness and neighborliness, which perhaps predate the laws that we're talking about, and still continue. So that's just a vague thought. I don't think that my observations are either clinical or of immediate significance, but these are really, having encountered so much pain, looking at people I met being thrown back to Afghanistan, a country they have never seen. I have really come to think about it, just how serious we are, in serious trouble, and our humanity and our compassion is reduced to nothing by the frameworks that we're talking about. So just a thought, yeah. But anyways, I think the fact that we're thinking about these issues is a start.
No, I agree with that completely, and I think there are the kind of political theorists that work in this space about the right to belong is also really important to engage with that thinking, and a lot of that literature comes from Europe and the USA, Canada, Australia, and there is a real need for more of that thinking, which also exists, of course, but is thinner. There's less of it in the post-colonial context. What is it to be Zambian in the context of the colonial creation of the thing that we now call Zambia? And in that context, there are some really nice statements from the African Commission, specifically in relation to Zambia, in the context of the Kenneth Kaunda case. He'd been president for 27 years. He stepped down after losing an election, then tried to run again at the next election, and miraculously he was no longer Zambian. In fact, he'd been Malawian all this time. He'd been president of Zambia, and a very nice. I mean, it came late, but the African Commission making a very nice statement that to suggest that a person whose parents came from another part of the British Empire cannot therefore be Zambian is absurd and against all principles of human rights. Of course, I'm not quoting it in the proper language, but that statement. And I think that there are some other really nice statements from the African system in the context of Kenya, in the context of Cote d'Ivoire, where there have been these crises. And I think this effort to create a legal normative framework, even if we are not naive about the direct applicability of these judgments, is important to keep that the idea of international law alive, after all.
Thank you, Umar and Bronwyn, for addressing this question. And thank you, Chance, for bringing up this very important issue. Unfortunately, we are at the end of our workshop. We've gone 7 minutes past our scheduled time. In fact, and I can see that there are still raised hands. However, I encourage you to perhaps reach out to us. I'll just quickly drop in my email ID and we can reach out to the panelists and help you get the answers that you're seeking. Yeah, Maureen, I think, do you want to go ahead?
Yeah, thank you, Nandini. I would like to thank each of our panelists for your very powerful insights and deeply grounded inflections. I think you've been able to give us context from different backgrounds, different cultures, and different legal pathways to access to citizenship. And today's discussion has illuminated the multifaceted nature of citizenship struggles across diverse contexts, where identity, legal status, and belonging remain contested for many children born to refugees and migrants. I would also like to thank our participants for taking time to join us in these important discussions on access to citizenship for refugee and migrants children. And as we move forward, may we continue to share strategies, challenge systemic inclusions, amplify the voices of those affected communities, because citizenship is not just a legal status, it is a foundation for dignity, opportunity, and identity. Thank you all and enjoy the rest of your day. Thank you.
Thank you so much, everyone. I quickly saw there was a question about the recording of today's workshop. We will be posting it on our website and we'll send you an email regarding it. And thank you again to all the panelists, to all the participants. Absolutely impossible to hold this workshop without you. Yeah. If you have any questions, I think almost all of you should have my email ID. I'll just drop it here along with the GSLC registration form, which I mentioned earlier, and mine and Marine's email IDs in case you want to reach out to either of us. Thank you so much.